So are we live? Am I audible? Okay. So we did a discussion with respect to the test series, and we did cover question 1 to question number 29. Okay. हमने टेस्ट का डिस्कशन किया था. अभी इस वीडियो में what we'll be doing is we'll be discussing question from question number 30 and we'll be covering the rest of the test to question number 50. Okay. So let's start with the very first question, which is your question number 30, which is on fundamental duties. ठीक है. So fundamental duties के ऊपर question है. Consider the following statements regarding fundamental duties under Part 4A of Indian Constitution. They were incorporated into Constitution upon recommendation of Swaran Singh Committee. Unlike certain fundamental rights, the fundamental duties are confined only to citizens of India and do not extend to foreigners. ठीक है. So, before I get into the explanation, let me just tell you again, although हमने first video में भी discuss किया था, the purpose here is to, first of all, ये sectional test है हमारी test series का, ठीक है, and this is a discussion. So, purpose क्या है? To identify how to get question correct. ठीक है. The purpose is not to cover content from this, although because हम question answer discuss कर रहे हैं तो conceptual discussion तो होगी, but the purpose here is not just the conceptual discussion. The purpose is also to identify कि question solve कैसे किए जाते हैं. ठीक है. So the purpose is कि the design of paper is such that it is based on the UPSC pattern. ठीक है. Type of question are being asked as a blend of easy, medium, and difficult, and I have labeled them accordingly. So this one is an easy question, and now let's get to the explanation of this particular question. So the very first thing that we have mentioned here is that they were incorporated into Constitution upon the recommendation of Swaran Singh Committee. Now that point is very correct. This is right. Unlike the fundamental rights, fundamental duties are confined only to citizens and do not extend to foreigners. This is also correct. See, understand from the perspective of the constitutional makers. Fundamental duties सारी foreigners को available नहीं हैं, but there are certain set of fundamental duties that are necessary कि वो available हो foreigners को भी. ठीक है. Fundamental rights, sorry. ठीक है. But when it comes to fundamental duties, it is the duty of the citizens. It cannot be imposed on foreigners. ठीक है. So that is why both the statement are correct, and right answer here is C. Then come your question number 31. Now that was a very easy question. ठीक है. जिसने थोड़ा सा भी पढ़ा है या थोड़ा सा भी कॉमन सेंस का इस जैसे स्वरण सिंह वाला तो आपने पढ़ा होना चाहिए, अदरवाइज आपको नहीं आता, बट द सेकंड स्टेटमेंट वो सेल्फ एक्सप्लेनेटरी, उसमें कुछ ज़्यादा एक्सप्लेनेशन और लॉजिक डिडक्शन की रिक्वायरमेंट थी नहीं. ठीक है. Now, second is with reference to fundamental duties under Part 4A of Indian Constitution, consider the following statement. Swaran Singh Committee recommended inclusion of duty to pay taxes, but this recommendation was not incorporated into the Constitution. This is first statement. Second is the constitutional text of 4A expressly empowers Parliament to impose legal penalties or punishment for non-compliance of these duties. Third is, according to Supreme Court jurisprudence, if a law seeks to give effect to any fundamental duty, the court may consider such a law be reasonable in relation to the restriction imposed on fundamental rights. ठीक है. तो यहाँ पे थर्ड स्टेटमेंट करेक्ट है, फर्स्ट स्टेटमेंट भी करेक्ट है, लेकिन सेकंड स्टेटमेंट इनकरेक्ट है. नाउ लेट्स डिस्कस व्हाई स्टेप बाय स्टेप. नाउ वेरी फर्स्ट थिंग कि स्वरण सिंह कमेटी ने टैक्स वाले पॉइंट के लिए बोला था दैट शुड बी इनकॉर्पोरेटेड एज अ फंडामेंटल ड्यूटी, लेकिन कांग्रेस गवर्नमेंट ने रिजेक्ट किया था ड्यूरिंग ड्राफ्टिंग ऑफ 42nd अमेंडमेंट एक्ट. वन ऑफ द मेजर रिजेक्टेड रिकमेंडेशन थी उसकी ये वाली कि आपको टैक्स को नहीं पे करना है, ठीक है। सो बेसिकली फंडामेंटल ड्यूटीज वर ऑल्सो इनकॉर्पोरेटेड अंडर 42nd अमेंडमेंट एक्ट, एंड दैट इज वाई you have part 4A. Whenever you see A in the constitution, that implies कि वो amendment से आया है, ठीक है। Another place where you will see A and B is with respect to cooperatives and municipalities. So I want you to tell me which constitution articles am I talking about? Parts am I talking about? Please let me know in the comment section. Okay. Second is the statement second is incorrect. Although Parliament has the power to frame laws, but it does not come from Part 4A of the Indian Constitution. That was second statement is incorrect. Third statement is correct because the Supreme Court ने 1992 रामेश्वरन केस के अंदर establish किया था that fundamental duties justiciable तो नहीं है, but they have a interpretative value, and अगर कोई legislative enact करता है implement करने के लिए fundamental duties को, the court will consider it as a reasonable restriction on fundamental rights guaranteed under Article 14 and 19, thereby saving law from being struck down being unconstitutional. ठीक है, so this is why your correct answer here is only 2. Then come the topic of amendment. With reference to the procedure of amending the Constitution of India under Article 368, consider the following statement. A constitutional amendment bill can be introduced in Parliament only by a minister and not a private member. ठीक है, see, amendment of constitution is very tricky area, very important area, very interesting area, and you must be reading about it thoroughly, ठीक है, because you can get a number of questions from this area as well. ठीक है, तो first statement is incorrect. देखो, constitutional amendment bill प्राइवेट मेंबर भी इंट्रोड्यूस कर सकते हैं, ठीक है। तो फर्स्ट स्टेटमेंट इज इनकरेक्ट. And why do you think this provision was given? So if you try to deduce it logically, the reason could be uh, the members of the parliament are representing whom? They are representing people. Now if they are representing people, they have to be the voice of people, ठीक है। Since India is a democratic country, that is rule of people, by the people, for the people, है ना, तो आपका रूल पीपल के लिए है ना, पीपल को रिप्रेजेंट करें मेंबर ऑफ पार्लियामेंट। सो कॉन्स्टिट्यूशनल अमेंडमेंट अगर होगा तो प्राइवेट मेंबर्स को आप क्यों मना करोगे? बिकॉज दे कैन ऑल्सो कम अप विथ समथिंग विच इज इन फेवर टू द वॉइस दैट दे आर रिप्रेजेंटिंग, ठीक है। ऑल दो वो पास होगा नहीं होगा, दैट इज सब्जेक्ट टू द पैसेज ऑफ लॉ इन द parliament itself, but at least you can allow them to raise their voice, raise their issues, and bring such constitutional amendment law that they think is good for the people that they are representing, ठीक है। सो दैट इज द लॉजिकल डिडक्शन कि प्राइवेट मेंबर को भी इसलिए अलाउ किया है बिकॉज बोथ ऑफ देम शुड हैव इक्वल पावर व्हेन इट कम्स टू रिप्रेजेंटेशन ऑफ द पॉपुलेशन, ठीक है। Now, second is introduction of a constitutional amendment will require prior recommendation of President of India. Now, this is incorrect, and why this is incorrect? Now, think it logically. कि प्रेसिडेंट ऑफ इंडिया की अगर प्रायर रिकमेंडेशन चाहिए, what does that imply? That imply that you need the council of ministers to say yes to any bill that you are proposing, correct? Now imagine कि आपका जो प्रेसिडेंट है, ठीक है ना, प्रेसिडेंट वर्क ऑन व्हाट बेसिस? दे वर्क ऑन aid and advice of council of minister, and council of ministers are whom? Council of ministers are executive. Now if the executive is deciding whether you want to introduce a bill or not, that means your voice is being suppressed by the ruling executives, ठीक है। So that is why prior recommendation is not necessary when it comes to president of India. Oh sorry, when it comes constitutional amendment act, constitutional amendment bill की अगर introduction की बात कर रहे हैं, तो प्रेसिडेंट की प्रायर रिकमेंडेशन इज नॉट नेसेसरी. दैट मीन्स यू आर नॉट गिविंग इनहेरेंट veto to council of ministers, ठीक है। That is why this is incorrect. Then comes the question 33. Under Article 368 of Indian Constitution, certain provision required not just a special majority in Parliament, but also ratification by legislatures of not less than one half of state. Which of the following constitutional changes necessitate this state ratification? The very first is alteration of union, state, and concurrent list. Second is abolition and creation of legislative councils in the state. Amendment affecting the representation of state in the parliament. Then modification to directive principles of state policy. Now, if you see state ratification का आप एक logical thing समझो. State ratification. See, Indian polity is working on certain basic principles. ठीक है? What are those principles? That you have a democracy. ठीक है? You have a federation, and you have a federation with strong center. ठीक है? Now, so that is why आपकी जितनी भी policies होंगी, they will be giving center a little bit of more authority. But at the same time, since we are a federation, it is important that whenever you are changing anything with respect to the federation power itself, ठीक है? अगर किसी भी चीज़ को आप चेंज कर रहे हो जो इंडियन फेडरलिज्म को इम्पैक्ट कर रहा है, इंडियन फेडरेशन की यूनिट्स की पावर को इम्पैक्ट कर रहा है, तो देन दैट इज़ नेसेसरी कि वहाँ पे आपको उन फेडरल यूनिट की रैटिफिकेशन की रिक्वायरमेंट है. एंड व्हाई इज़ इट सो? First, so that they also feel heard and they should have a voice because it is substantially related to their power. Second, रीजन बीइंग कि यूनियन गवर्नमेंट ओवर पावर करके कंप्लीटली सेंट्रलाइज सिस्टम एस्टैब्लिश ना कर दे. सेकंड रीजन इज दिस. एंड थर्ड एंड द मोस्ट इम्पॉर्टेंट इज बिकॉज to have a peaceful functioning of the country, ठीक है? And to prevent internal chaos, some sort of civil war in country, ठीक है? Some sort of demands of secession from the country because you want to keep it as a unit. So in order to make all these things happen, you have to have certain sort of powers that need state ratification, and those are the features that will impact the federal. अब जहाँ पे भी स्टेट की पावर्स इम्पैक्ट होंगी वहां पे स्टेट की रैटिफिकेशन की रिक्वायरमेंट होगी. नाउ इफ यू कंसीडर दिस प्रिंसिपल इन योर माइंड, कीप दिस प्रिंसिपल इन योर माइंड, यू विल रियलाइज कि यहाँ पे अगर आप स्टेट कॉन्करेंट लिस्ट को चेंज करने की बात कर रहे हो तो असेंशियली आप उन सब्जेक्ट को चेंज करने की बात कर रहे हो जिसपे सेंटर स्टेट या फिर कॉन्करेंट लिस्ट किस सेंटर या स्टेट का अथॉरिटी है. ठीक है? तो इसका मतलब उनकी पावर्स इम्पैक्ट होंगी. दैट इज वाई इट इज इम्पॉर्टेंट कि वहां पे आपका स्टेट रैटिफिकेशन हो. नाउ कम टू लेजिस्लेटिव काउंसिल. लेजिस्लेटिव काउंसिल्स को तो रिक्वायरमेंट ही नहीं होती है कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट की. ठीक है? बिकॉज इट इज द स्टेट हु डिसाइड्स वेदर वी वांट अ कॉन्स्टिट्यूशनल लेजिस्लेटिव काउंसिल और नॉट. तो अगर स्टेट पास कर रही है उसके बाद स्टेट स्पेशल मेजोरिटी से पास करती है, उसके बाद सेंटर सिंपल मेजोरिटी से पास कर देता है, अप्रूव करता है सेंटर. सो उसकी डिमांड ही स्टेट से बिगिन होती है. तो यहाँ पे तो क्वेश्चन ही नहीं आता. Now, third is your amendment affecting representation of state in parliament. Now, this is also something that is taking away power or giving power to particular states. And that is why this also need ratification because वहाँ पे फेडरल फेडरेशन की यूनिट्स की पावर इम्पैक्ट हो रही है. ठीक है? नाउ फोर्थ इज मॉडिफिकेशन टू डीपीएसपीज. यहाँ पे फेडरेशन की पावर की कोई इम्पैक्ट नहीं हो रहा है फेडरेशन की पावर्स में बिकॉज डीपीएससी एसेंशियली समथिंग जो सेंटर और स्टेट दोनों को व्हेन दे आर मूविंग फॉरवर्ड एंड डूइंग सम पॉलिसी वर्क दे हैव टू लुक फॉरवर्ड कि वो डीपीएसपीज की डायरेक्शन के अंदर जाएं. दे आर डायरेक्टिव प्रिंसिपल्स. इट हैज नथिंग टू डू विद पावर ऑफ स्टेट और सेंटर. That is why the answer here is 1 and 3. So if you keep these basic principles of polity in your brain now, you will be in a better position to get your answers correct because आपका base अच्छे से secure होगा, आपके concepts अच्छे से clear होंगे. ठीक है? Now comes question 34. Consider the following inferences derived from constitutional procedure for amending the constitution under Article 368. ठीक है? The requirement of presidential recommendation for introducing constitutional amendment will enforce executive yield a constitutional veto over initiation of constitutional changes. Now, this is the same statement that we have discussed previously, but in a different language, just in order to make sure that you are alert enough to understand. Okay, so the first statement is incorrect. Okay. Second is the constitution provision requiring allowing a joint sitting to resolve deadlocks over amendment bills implies that the numerical superiority of Lok Sabha can lawfully override Rajya Sabha's vetoes in constituent matters. Now, दिस इज द एग्जैक्ट रीजन कि जॉइंट सिटिंग कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट के लिए अलाउड ही नहीं होती है बिकॉज अगर आप सीएए के लिए जॉइंट सिटिंग अलाउ कर दोगे तो पावर ऑफ बिकॉज लोकसभा के नंबर ज्यादा हैं तो दे विल गेन मेजोरिटी ओवर द राज्यसभा नाउ व्हाट इज राज्यसभा रिप्रेजेंटिंग स्टेट्स स्टेट्स की वॉइस सप्रेस हो जाएगी दैट इज वाई सेकेंड स्टेटमेंट इज ऑल्सो इनकरेक्ट सी ऑलवेज रिमेंबर दोज प्रिंसिपल कि इंडिया के बेसिक प्रिंसिपल क्या है वंस यू नो द बेसिक प्रिंसिपल्स ऑफ इंडियन पॉलिटी ना marking each and every question will become so easy for in your exam मतलब you will understand the basic principles and then you read and revise तो अच्छे से आप आंसर को मार्क कर पाओगे without any doubt and confusion things will be much sorted for you. Third is by explicitly prescribing a 6-month time limit for state assemblies to vote on federal amendments, Article 368 prevents states from exercising a pocket veto through legislative inaction. So there is no such time limit that has been prescribed. That is why none of the statement here are correct. Then come your question on basic structure. Now, the basic structure doctrine, a judicial interpretation that limits parliament amending power, was explicitly established by Supreme Court of India in which of the following landmark cases? Okay. So, basic structure of doctrine was established by the Supreme Court in Keshwananda Bharati case versus State of Kerala in 1973, and this is the one of the most important case. It is one of the highest bench, 13 judges का bench था जो आज तक बैठा है for giving any sort of judgment. I think recent one bench surpassed this or maybe was equal to this, but was the highest. ठीक है. Then comes question number 36. In early 2026, the Parliament passes the Strategic Infrastructure Land Acquisition Act. Now, this is a case study based question. Okay? To prevent the Supreme Court from striking down the act due to widespread petitions alleging severe violations of Article 14 and 19, the Parliament immediately passes a constitutional amendment to place this act in ninth schedule of the Constitution. The Attorney General argues that placing the Act in ninth schedule grants its absolute immunity from the judicial review. ठीक है. Now, Attorney General कि अभी हमने क्या करना है इस केस स्टडी के बेसिस पे विल रीड द फॉलोइंग स्टेटमेंट द अटॉर्नी जनरल इज कॉन्स्टिट्यूशनली करेक्ट एज आर्टिकल 31 बी एक्सप्लिसिटली प्रोटेक्ट्स any law placed in ninth schedule from being challenged on the grounds of violating fundamental rights regardless of when it was added. Now this is an absolute statement and this is an incorrect statement. We'll discuss why. Let's read other statements. Okay? And after that, we'll discuss this collectively. According to IR Kolo case, the Supreme Court has an authority to review the 2026 Act. If the Act violates the basic structure of Constitution, the ninth schedule will not protect it. Okay. Third is the Supreme Court established April 24, 1973 as a cutoff, and laws placed in ninth schedule after this date are subject to basic structure test. Now, what is this saying? अभी यहाँ पे second and third statement are correct, and why they are correct, let's understand briefly so that we are much aware of the basic structure doctrine. Ninth schedule initially protected absolute immunity from judicial review. But it was in this IR Kolo case in 2007 that Supreme Court said that your ninth schedule cannot have absolute immunity. Because हुआ क्या था किसी को कोई भी एक्ट को सरपास करना है फ्रॉम जुडिशियल रिव्यू से दे विल पुट इट इन नाइन्थ शेड्यूल एंड सेइंग कि नाइन्थ शेड्यूल को तो जुडिशियल रिव्यू बाईपास कर सकता है ठीक है तो जिसको जो एक्ट लाना है वो लेके आएंगे एंड दे विल पुट इट इन ninth schedule. It was basically with respect to, I think, reservation of seats. इन मेडिकल आई उसके रिगार्डिंग एक केस था जिसके बेसिस पे सुप्रीम कोर्ट ने पुट ये 9th शेड्यूल वाली बात बाहर आई थी, ठीक है। नाउ आईआर कोहलो केस के अंदर हुआ क्या था, सुप्रीम कोर्ट सेड यू कैन नॉट हैव ब्लैंकेट बैन ऑफ 9th शेड्यूल। ओके, यू हैव अ प्रोटेक्शन उसके अंदर जुडिशियल रिव्यू से, लेकिन इफ एनी ऑफ योर लॉ, ठीक है, इट ऑल्टर्स और गोज अगेंस्ट द बेसिक स्ट्रक्चर डॉक्ट्रिन, ठीक है, then that law can be struck down as unconstitutional. So that is why what happened was कि in 2007 the blanket immunity of 9th schedule was taken away. Now imagine कि डिसीजन आया 2007 के अंदर, लेकिन कट ऑफ डेट अप्रैल 24 1973 क्यों रखी गई थी, टू आइडेंटिफाई कि 1973 से डाले हुए पहले वाले सारे एक्ट आर इम्यून, लेकिन 1973 के बाद वाले एक्ट कैन बी टेस्टेड ऑन द बेसिस ऑफ देयर resonance with the basic structure doctrine, ठीक है। Why? Because it was in Keshwananda Bharati case on 24th April 1973 that Supreme Court gave the doctrine of basic structure as we discussed in the previous question, ठीक है। And that is why in that particular ईयर वॉज केप्ट एज अ कट ऑफ, क्योंकि उस दिन बेसिक स्ट्रक्चर डॉक्ट्रिन को एस्टैब्लिश किया गया था, तो उसके बाद में ऐड किए जाने वाले सारे एक्ट मस्ट कंप्लाई विद बेसिक स्ट्रक्चर डॉक्ट्रिन। ओके, आप कुछ भी बना सकते हो, लेकिन आप बेसिक नेचर ऑफ पॉलिटी को चेंज नहीं कर सकते कि कल को तो कोई अथॉरिटेरियन रिजीम है, ये बोल के डाल देगा एक्ट 9 शेड्यूल में एंड इट विल गेन ब्लैंकेट इम्यूनिटी, दैट कैन नॉट हैपन, ठीक है। So this was the premise. That is why correct answer here is second and third. Then come question number 37. Over time, the Supreme Court has identified various elements as a part of basic structure of the Constitution. Consider following pair of landmark judgments and specific basic structure element they prominently affirmed. Now, this is a very factual question, ठीक है, and it is very difficult also कि आपको याद रहे, but just for testing your factual knowledge and कि कितना आपको याद है कितना नहीं है, उसके लिए सिर्फ जो बहुत इंपॉर्टेंट केसेस थे उनको पिक किया गया है यहाँ पे। जैसे इंदिरा इंदिरा गांधी वर्सेस राज नारायण के अंदर फ्री एंड फेयर इलेक्शंस को ऐड किया गया था। मिनर्वा मिल्स यूनियन ऑफ इंडिया के अंदर द बैलेंस बिटवीन फंडामेंटल राइट्स एंड इलेक्टिव प्रिंसिपल, अब ये तो बहुत ही फेमस जजमेंट है, ठीक है। Third is your SR Bomai and Union of States. This is with respect to federal nature. So these three are very prominent judgments. तो ऑल्दो आपको सब जजमेंट्स का नहीं याद रखना है, लेकिन कुछ जजमेंट्स बिकॉज इनको तो आप लिखोगे भी अपने आंसर्स के अंदर मेंस में बार बार, ये आपको याद। मिनर्वा मिल्स इज अ वेरी की जजमेंट, आयर कोलियो केस इज अ वेरी की जजमेंट, एस आर बोमाई इज अ की जजमेंट। जितने भी फेडरल वाले आते हैं उसके अंदर एस आर बोमाई केस की बात होती ही होती है, फेडरेशन सेंटर स्टेट रिलेशन के क्वेश्चंस आएंगे। देन योर केशवानंद भारती इज अ की जजमेंट। सो दीज आर सम ऑफ की जजमेंट्स, द लैंडमार्क जजमेंट्स। जैसे पुट्टू स्वामी जजमेंट है, आपको याद होना चाहिए राइट टू प्रिवेसी के बारे में, तो दीज आर द की जजमेंट दैट यू शुड रिमेंबर, ठीक है। तो सॉरी, ऑल थ्री पेयर्स आर करेक्ट। देन कम क्वेश्चन नंबर 28 ऑन पार्लियामेंट्री सिस्टम, ठीक है। The fundamental defining characteristic that distinguish parliamentary system of government in India from presidential system. Basically, parliament versus presidential system का question है, just घुमा के लिखा है, ठीक है। A strict separation of powers between legislature and the executive. So in India, what we have? We have parliamentary system, and what we have in US is presidential system, ठीक है। So we do not have a strict separation of legislature and executive are a part of legislature only. So that is why first statement here is incorrect. That is not a sign of a parliamentary system. Second is the collective responsibility of executive to popular house of the legislature. Now this is correct. Okay, but let's before marking, let's see the other options as well. The direct election of head of state by citizen, and डायरेक्ट इलेक्शन ऑफ हेड ऑफ स्टेट तो नहीं होता, प्रेसिडेंट इज इनडायरेक्टली इलेक्टेड नॉट डायरेक्टली इलेक्टेड। डायरेक्ट कौन इलेक्ट करता है, हम लोकसभा को इलेक्ट करते हैं डायरेक्टली। देन द पावर ऑफ लेजिस्लेचर टू डिक्लेयर लॉ अनकॉन्स्टिट्यूशनल थ्रू जुडिशियल रिव्यू। So right answer here will still remain the same, collective responsibility. As we all know, our executive is collectively responsible to Lok Sabha. And what is Lok Sabha? Popular House. That means directly elected house. Okay. That is why the right answer here is B. Now, our question 39 is the Indian parliamentary system is largely modeled on British Westminster system, yet it fundamentally differs from it in several aspects. Consider the following statement regarding these differences. So, unlike the British system, which is rooted in doctrine of sovereignty of parliament, the Indian parliament is not supreme and operates within a limited framework. So, this statement is correct. Ki what do we have? We have constitutional supremacy, whereas what does UK have? UK have parliamentary supremacy. Okay. So what do we have? Constitutional supremacy. So that is why first statement is correct that our parliament work in limited framework, and that limited framework is designed by the Constitution of India. In the British system, a minister must be a member of parliament, whereas in India, a person who is not a member of parliament can be appointed as a minister indefinitely, provided they secure the prime minister's confidence. So the statement, though is partially correct, is incorrect also. Why? Let us understand. Though in India, a member of parliament, a person who is not a member of parliament can become the minister. That is true, but cannot become minister indefinitely. He or she has to become the member of parliament within a span of 6 months. ठीक है? Within a span of 6 months, that person has to become a member of parliament. And the latest case of this that I can remember is of, I think, Mamta Banerjee in last state assembly elections. If I am not wrong, she although lost her seat in the first elections, became the chief minister. Then through by-elections, she came and become the member of the state legislative assembly. Okay. So that is why correct answer here is A only. Now consider the following statement regarding interplay of executive power, collective responsibility, and resolution in Indian parliamentary system. So the constitution explicitly mandates that the president is bound by advice of council of minister to dissolve the Lok Sabha, even if the council has just lost a vote of confidence on the floor of house. So the first statement is incorrect. Why so? Because agar council of minister ne they have lost the trust, so they cannot aid and advise. यहाँ पे प्रेसिडेंट की सिचुएशनल जस्ट अ सेक यार सिचुएशनल डिस्क्रिशन आती है ठीक है in which he or she can ask another mid party who he thinks or who thinks have the majority to go for a floor test and prove their majority ठीक है so that they can become the uh, new prime minister or chief minister ठीक है so that is why the correct answer the first statement is incorrect. The second statement is the constitutional principle of collective responsibility means that no confidence motion can be targeted against an individual minister for several policy failures in their specific department. Now, this is exactly opposite of what it has written. It cannot be targeted on the individual minister. The name says collective responsibility. That means it is a collective responsibility of the executive council. Okay, so that's incorrect. Third is even after dissolution of Lok Sabha, the Council of Ministers does not cease to hold office, ensuring the president is never left without a constitutional aid and advice. This statement is correct, and this particular thing is called as caretaker government. कि डिसोल्यूशन के बाद भी दे डू नॉट लीव द हाउस सो दैट दे कैन aid president. ठीक है, that is why the correct answer here is C, 3 only. Then come question number 41. The 42nd Constitutional Amendment Act significantly altered the federal balance by transferring 5 subjects from state list to concurrent list under the seventh schedule. Which of the following subjects were among those transferred? So the right answer is education. 5 सब्जेक्ट ट्रांसफर किए गए थे जो कि थे एजुकेशन, फॉरेस्ट, वेज एंड मेजर्स, प्रोटेक्शन ऑफ वाइल्ड एनिमल्स एंड बर्ड्स एंड एडमिनिस्ट्रेशन ऑफ जस्टिस. ठीक है. Then come your question number 42, which is an assertion reasoning type of question. ठीक है. Assertion says the structural independence of Supreme Court is indispensable prerequisite for sustaining the federal character of Indian Constitution. Now, this is statement is correct. Why? Because if you want to maintain the federal character, you have to have an independent arbitrator. ठीक है. Otherwise, one can overpower other if you don't have an independent arbitrator. That is why first statement is correct. Now reasoning क्या बोल रहा है? A federal system inherently requires an impartial constitutional arbiter to resolve judicial conflicts between union and states, ensuring neither level of government unilaterally encroaches upon the other designated sphere of power. Now this statement is correct and is a correct reason for assertion because this is what we discussed now. So the correct answer here is A. Coming to 43rd question. Consider the following statement regarding conceptual framework of asymmetric federation and nature of Indian Union. Now, यहाँ पे समझने वाली बात क्या है? What is asymmetric federation? Asymmetry, name is saying it does not have a symmetry. It is not symmetrical for all. It is not similar for all. Federation है, but some have more power, some have less power, some have more privileges, some have less privileges. Which is asymmetric federation. ठीक है. Now let's read the statement keeping this in mind. Unlike the United States, India is holding together federation where federal structure is not the result of agreement among pre-existing independent sovereign state. Now this is correct because if you remember in the previous discussion, we also discussed the difference between union versus federal and difference between US versus Indian federation. ठीक है, we did discuss that. ठीक है. Now, the Constitution exhibit horizontal asymmetry by guaranteeing an equal number of seats in Rajya Sabha for all states, regardless of their geographical size and population. Now, this cannot be true even if you don't know because India is a democracy and we representation is on the basis of population. ठीक है. और राज्यसभा में सारी states की seats equal नहीं है. States are divided on the basis of number of population on that particular state. ठीक है. Now third is the special constitutional provision enacted under Article 371 AJ for specific states are deliberate example of asymmetric federalism designed to accommodate regional disparity and protect tribal identities. Now this is correct because when you are giving us considering some states are poor and they need more support like after independence there was a term called Bimaru states. ठीक है. तो उनके लिए गवर्नमेंट यूज टू गिव मोर ग्रांट्स एंड एड्स रादर देन द बेटर ऑफ स्टेट्स. ठीक है. सो दैट इज वाई जैसे इट ग्रांट स्पेशल एडमिनिस्ट्रेशन लेजिस्लेटिव ऑटोनॉमी टू सर्टेन स्टेट इन नॉर्थ ईस्ट, गुजरात, महाराष्ट्र, आंध्र प्रदेश एटसेट्रा to respect local custom, protect tribal land right, address historical economic backwardness, providing that all states do not share the exact same relationship with the center. ठीक है. That is what do we actually mean by asymmetrical federalism. Then comes center and state relations. Now, the very first and the easiest question of all is consider the following statement regarding interstate council under Article 263 of Indian Constitution. It is a permanent constitutional court established specifically to adjudicate binding legal dispute between two or more states. First of all, it's not permanent. Second, it does not adjudicate binding legal. It is an advisory body. ठीक है, so first is incorrect. The council is chaired by Prime Minister of India, that is true. And the vice chairmanship is by the state CM of uh, the council, ठीक है, and it rotate on the base all yearly basis के ऊपर, ठीक है. So correct answer is B. With reference to interstate council, again on interstate council under 263, consider the following statement: permanent body है नहीं, which is mandated to reconstitute after every 5 years. No, it is not a permanent body, so that is incorrect. It was first established in 1990 based on recommendation of Sarkaria Commission. This statement is correct. So second, okay, they are asking incorrect statement. The right answer here is A. ठीक है, one only. Then comes consider the following statement regarding administrative and statutory framework of zonal councils. Unlike the interstate council, zonal councils are statutory body established under provision of State Reorganization Act. Now this is correct. देखो जो interstate council है that is a constitutional kind of constitutional से उसका origin हुआ है, लेकिन zonal councils का mention भी नहीं है constitution के अंदर, that is why it is a statutory body. ठीक है, first is correct. The second is Union Home Minister serve as a common chairman for all zonal council, while the chief ministers of the state respective states act as vice chairman on annual rotation basis. That is correct. Just a sec. Then come the third. I think in previous question I spoke about zonal council, so make that correction. By mistake, I did that. Then the third is to ensure comprehensive regional integration. The State Reorganization Act of 1956 established 6 zonal council, which included Northeast Zonal Council for 7 sister state. ठीक है, नहीं ये बाद में एस्टैब्लिश हुआ है. 6 zonal councils पहले एस्टैब्लिश हुई थी. दे आर एस्टैब्लिश अंडर स्पेशल एक्ट, नॉर्थ ईस्ट जोनल काउंसिल एक्ट आई गेस. ठीक है, नॉर्थ ईस्ट काउंसिल एक्ट 1971 में. सो दिस इज इनकरेक्ट. तो राइट आंसर हियर इज C 1 and 2. Then is the Constitution of India provides specific exceptional circumstances under which the Union Parliament can legislate on subject enumerated in the state list. ठीक है, consider the following statement regarding these parliamentary overrides. Under 252, if two or more states pass a resolution requesting Parliament to legislate on the state subject list, those specific legislature permanently surrender their constitutional power to amend or repeal the resulting parliamentary act. This statement is correct. Laws enacted by Parliament on state list subject during a national emergency and during president rule both automatically cease to operate 6 months after the respective emergency or rule is revoked. Now, this is incorrect. We'll discuss why. देखो होता क्या है, national emergency, the overriding law became inoperative exactly 6 months after the emergency ceases. लेकिन president rule के अंदर the law made by parliament do not automatically expire. They continue to remain in force even after president rule is lifted until the newly elected state legislature decide कि उसको repeal करना है या amend करना है. ठीक है, that is why statement 2 is incorrect. Under the doctrine of repugnancy, if a law on the concurrent list subject conflict with central law but successfully secures the president assent, the parliament is constitutionally barred from enacting any future overriding legislation on that. Now, this statement is incorrect. Parliament कभी भी बाहर नहीं होगी for overriding acts के लिए. This is not in sync जो हमने unitary constitution के बारे में बात किया इंडिया के. So this is not in sync. So right answer here is A. Sorry, D, only one. Then is with reference to constitutional provision under Article 312, All India Services के बारे में discuss. Consider the following statement. A resolution to initiate creation of new All India Service must be passed by Rajya Sabha by a special majority, which require both majority of total membership of the house and not less than two-third members of present and voting. Now this is incorrect. So there are three kind of special majority and then there is effective, absolute and simple majority. So if you want to read about those majority, I have created a video. I'll ask the team to put the link in the description. I have tried to simplify it as much as I can. So you go and read about the types of majority. And if you want, I can take a special session on types of majority as well. Please comment down below if you want to have that session. Okay. So it does not require this much of majority. It requires only a special majority of not less than two-third of member present and voting. Okay. The constitution enable creation of an all India judicial service but explicitly restrict its scope by ensuring it cannot include any post inferior to district judge. This is absolutely correct. कॉन्स्टिट्यूशन में साफ साफ लिखा है कि डिस्ट्रिक्ट जज से नीचे वाली पोस्ट के ऊपर आप ऑल इंडिया सर्विस नहीं बना सकते. Once the Rajya Sabha passes a requisite resolution, the Parliament must enact a Constitutional Amendment Act under 368. This is not a correct. Constitutional Amendment Act की requirement नहीं होती. Ordinary law से Parliament बना सकती है. So correct answer here is D, 2 only. Now, with reference to the constitutional division of financial powers between the Union and State, 271 empower our Parliament to levy surcharge or certain taxes and duties. Entire proceeds which form the constitutional fund of India are strictly excluded from divisible pool shared within the states. Now the first statement is correct. जो सरचार्ज और लिवाइस की जो लिवाई होती है उसकी जो फीसेस होती हैं दे गो टू CFI कंसोलिडेटेड फंड ऑफ इंडिया, लेकिन वो डिविजिबल पूल बिटवीन सेंटर और स्टेट का शेयर नहीं बनती हैं. ठीक है. सो अगर आपको यहाँ अगर आपने पढ़ा है तो जो फाइनेंशियल कमीशन की रिकमेंडेशन थी उसके अंदर वी हैड अ डिस्कशन अबाउट दिस एंड दिस वाज समथिंग व्हिच वाज डिबेटेड. सो गो एंड रीड अबाउट फाइनेंशियल कमीशन इशू जो इस बार का था. दिस वाज द क्रिटिकल अप्रेजल जो किया गया था एक्सपर्ट्स द्वारा. ठीक है. Statutory grants provided to states in need of financial assistance are dispersed under 282, acting as a mandatory charge of Consolidated Fund of India based exclusively on Finance Commission recommendation. So this is not Article 282, this is Article 275. So that is why this is incorrect. Under the constitutional architecture governing the good GST, the recommendation of GST Council hold persuasive value but not legally bind the sovereign legislative competence of union and state. तो ये स्टेटमेंट सही है तो राइट आंसर हियर इज 3. ठीक है. सुप्रीम कोर्ट ने क्लैरिफाई किया था इन यूनियन ऑफ इंडिया वर्सेस मोहित मिनरल केस के अंदर दैट simultaneous power to parliament and state legislature to legislate on GST is granted by Article 246A. ठीक है. Now come the last question, which is your question number 50. With reference to legislative, executive, and financial dimensions of Indian federalism, consider the following statement. The constitutional strictly restrict the state government from borrowing outside the territory of India, retaining external sovereign debt as an exclusive domain of union government. Now, this statement is correct, but I have a question to ask here. This is true that constitution bars state to get funds from outside the India. They are restricted to borrow only within the territory of India. Having said that, अगर आपने अभी देखा है तो दिल्ली गवर्नमेंट ने विंटर पोल्यूशन को केटर करने के लिए एक कुछ बिल निकाला है, कुछ पॉलिसीज निकाली हैं, जिसके लिए दे हैव रिसीव्ड फंड फ्रॉम वर्ल्ड बैंक. हाउ इज दिस पॉसिबल? दिस इज पॉसिबल because of center, because it is not the Delhi government that is buying on its behalf. It is the center who is taking loan on its behalf and then giving it to the state. The center is buying on the behalf of Delhi government from World Bank a loan to counter Delhi pollution, ठीक है, winter pollution. So that is why you keep in mind. एंड दिस क्वेश्चन कैन कम बिकॉज ऑफ दिस पर्टिकुलर इशू ओनली कि आपके माइंड में होगा कि दिल्ली गवर्नमेंट ने तो वर्ल्ड बैंक के साथ किया तो दिस इज डुएबल. नो, दिस इज नॉट डुएबल. ठीक है. अंडर द डॉक्ट्रिन ऑफ रिपेंजेंसी, दिस इज द सेम थिंग दैट वी आर डिस्कस्ड. The Constitution explicitly grants the Union power to issue executive directions to state ensure compliance with central laws, and state failure to follow these directions constitute a valid constitutional ground for imposition of president rule. Now, this statement is correct, absolutely correct. ठीक है. So right answer here is only 2. 1 and 3. इसका मतलब क्या है कि सेंटर has a power that it can issue direction to state to follow certain laws or comply with certain laws. But if state doesn't do it, you will have you can have presidents rule. And why do we do so? ऐसा क्यों है? Because of what we had discussed. We want to keep a united India. We don't want a balkanized India. So we wanted a federation with a strong center so that we can stay in a unit. And that is why federation units were not given equal power to center. They were given less powers because we don't want to go to the stage of balkanization. So किसी भी तरह के any sort of dissent, any sort of non-compliance from state is at a macro level, not for the minute things, na, is not tolerated by the constitution itself. ठीक है? In order to make it 1 unit, keep it a 1 unit. ठीक है? So this was the test discussion, guys. Now, if anybody of you wants and go appear in the test, so you can go to this website www.manikaias.com. There, what you can do is go to test series. There you will find open test. Give that test. It is available for just rupees 1. It is the same test, and then you can also enroll for the test series. The prelim test series is available for just 2499, and it includes 50 plus test of like these quality questions, in which you have sectional half length test, and then you have a full length sectional test, and then you have comprehensive test. Okay, so please do it. It will be very beneficial for your preliminary examination, and I guarantee this is based on the current UPSC pattern, and you will not regret taking it. It is just for 2499. Please try it out, it's very good. Okay, so and if you have any doubt, please ask your doubt in the comment section. Okay, but till then, bye bye, take care, see you again next time.